Welcome to Chapter 2 of School Law. Chapter 2 started off with talking about the First Amendment. The Constitution initially lacked explicit references to religious liberties for U.S. citizens, but the Bill of Rights addressed this gap by guaranteeing religious freedoms and maintaining the separation of church and state. Over time, conflicts between church and state have arisen, leading to legal disputes regarding religious practices in public schools. The First Amendment, with its establishment and free exercise clauses, prohibits government support for religion and interference with individual religious freedoms, ensuring a neutral stance in public institutions like schools. The Establishment Clause for the First Amendment has significant implications for public schools, requiring neutrality in religious matters to prevent government endorsement of religion. The endorsement and coercion tests are used to assess potential violations of the Establishment Clause, ensuring that the government actions do not coerce individuals into supporting or participating in religion against their will. Recent legal cases have highlighted the importance of maintaining a clear separation between government and religion to uphold individual freedoms and prevent any perception of government favoritism towards a particular religion. Silent prayer and meditation. State legislatures have tried to support the quiet reflection and contemplation in schools, but faced opposition from parents and community members. The U.S. Supreme Court's ruling in 1985 on Wallace versus Jaffrey addressed silent contemplation and prayer in schools, deeming laws promoting voluntary prayer unconstitutional as they implied religious endorsement. However, student-initiated contemplation is permitted as long as it does not disrupt education, allowing students to reflect for stress relief or mental preparation without school direction. Aid to parochial schools. Support from the public for parochial schools has sparked legal discussions, especially concerning matters like complementary educational materials, transportation assistance, tax benefits, and additional services. Court rulings have been diverse, often hinging on whether support directly benefits the students or supports parochial institutions. The principle of benefiting the child is considered to evaluate if the assistance primarily serves the students attending parochial schools. Excessive involvement of the state in religious activities can lead to the aid of being prohibited due to violations of the First Amendment. The conversation surrounding public support for parochial schools continues to be controversial, with proponents advocating for revisions in legal judgments. Efforts have been initiated to overturn decisions that restrict public school educators from offering help in parochial institutions, and recent legal battles like Agostani versus Felton have shed light on the complexities of providing educational services to students in religious schools under Title I programs and the constitutional aspects linked to such support. Landmark cases such as Lemon versus Kurtzman and Early Decentio have established significant legal benchmarks related to the government aid for parochial schools. The Lemon test, which evaluates the constitutionality of laws concerning religion, highlights conditions such as having secular objective, not promoting religious beliefs, and preventing excessive interference. Different court decisions on practices associated with the assistance for parochial schools have been witnessed, with some actually being declared unconstitutional, while others have been acceptable. Recent verdicts, including Mitchell and Helms, have further influenced the support provided to students in religious schools, emphasizing impartiality and non-ideological assistance with such initiatives.
Now moving into religious symbols and displays. So public schools may not display religious exhibits or other visual materials based by the Constitution. It may be appropriate, however, for public school teachers to acknowledge and explain the various holidays of all cultural and religious groups as a unit in cultural heritage or some other related subject, as long as a secular purpose is served. Some legal battles over the display of religious symbols in public schools include like posting of the Ten Commandments or other religious portraits, and there have been many cases revolving around this topic, and they have been ruled unconstitutional due to the violation of the Establishment Clause of the First Amendment, and also sometimes a violation of separation of church and state. Moving into school-sponsored activities, commencement exercises in any type of school-sponsored prayer at athletic contests is deemed to be a violation of the First Amendment. The principle of neutrality mandates that public schools remain neutral in all matters relating to religion. Prayer at athletic contests. So prohibition of prayer at school events was given a major thrust when the U.S. Supreme Court in a 6-3 ruling in Santa Fe Independent School District versus Jane Doe banned student-led prayer and athletic contests, graduations, and other school-sponsored events. So this case kind of revolved around a policy that allowed the school's student council chaplain to deliver a prayer over the public address system before each home football game. And this was challenged by many Mormon and Catholic students under the Establishment Clause of the First Amendment. The school then made multiple changes to the policy, but the court ruled that the delivery of the message was not characterized as private speech just because it was at a public event and the people there didn't have a chance to it wasn't very private, so it was not categorized as private speech. The use of school facilities by religious student groups. Congress passed or attempted to address, the facility use when it passed the Equal Access Act in 1984 for the express purpose of providing student religious groups or clubs equal opportunities to access high school facilities as other non-curriculum clubs enjoyed. Under federal statute, it is unlawful for any public secondary school that has created a limited open forum to deny access to student-initiated groups on the basis of religion, political, or philosophical content of their speech. A limited open forum exists when an administrator allows one or more non-curriculum related student groups to meet on school premises during non-instructional time. So with these meetings of religious groups, the meeting should be voluntary and student-initiated. There is no sponsorship of the meeting by the public school. Employees of school are present at meetings but cannot participate, and they just must supervise, cannot participate in any way. The meeting does not interfere with educational activities within the school, and then the meeting is not controlled by any school personnel. So if a religious group wants to come into the school and use the facilities, the school personnel can be there just to supervise, but they really can't participate in any realm of the activity at all. And then religious activities and holiday programs. So the observance of holidays by public schools is clearly an unconstitutional activity if conducted in a devotional atmosphere in the public school system. The First Amendment prohibits states from either aiding religion or showing preference of one religion over another. And then public schools may not celebrate religious holidays. There should be no worship or devotional services, religious pageants, or plays of any nature held in the school. However, certain programs may be conducted if a secular purpose is clearly served.
Okay, getting into now the distribution of religious materials. Public school personnel are not permitted to distribute religious materials on a school premises. Such practice would be a clear violation of the Establishment Clause. So obviously teachers or school staff personnel cannot be handing out brochures or Bibles or anything that would promote what they believe. Public school officials may also may not allow religious groups to distribute religious materials on school grounds. Support of such practices would suggest that the school embraces religion and could suggest preference of one religion over another. So that is why all matters concerning religion are prohibited. Now, teaching the Bible in schools has been a ginormous controversy. So, the Bible may be taught in public schools if it is not offered for religious purposes. Now, this is one thing that they have talked about where we have seen a lot of famous poets and authors reference the Bible. So it is important to, if you are introducing the Bible in whatever lecture that you are giving, that you are not swaying your audience one way or another. You're maintaining a neutral demeanor. Like I said, famous authors and poets in the past have referenced it, such as Mark Twain and Shakespeare. So it can be taught to facilitate an understanding of the best literacy works and historical works, such as contemporary speech and writing. Now, Bible teaching may not be associated with any form of worship and must be taught objectively as a component of the secular program. So some schools are advocating for it because they believe that the knowledge of the Bible is critical in understanding best literacy works as well as profound writing. And if you go to page 38 of your textbook, you are going to see some fantastic court cases concerning the matter. Some of the parents in school districts are for implementing the Bible into the instruction, and some are against. Which leads me to my next topic of debate: intelligent design. This is another kind of controversial concept. It suggests that certain features of the universe include living things, exhibit characteristics of a product derived from an intelligent cause rather than natural selection. So this is the faith-based approach. It's the theory that the universe and its life cannot be explained solely by natural causes. Supporters of this theory believe that God is the ultimate designer of living things is God. District court held that it is unconstitutional to teach intelligent design in public schools. And this is where you're going to get a lot of the controversy again. On page 39, parents are in an uproar due to some schools that are introducing intelligent design, along with the theory of evolution. Some just want evolution, some just want ID. Some of them do not want either brought into the schools. So like I said, on page 39, there's a lot of controversy in court cases that you can refer to on that matter.
So you want controversy? So let's talk about the theory of evolution. So the theory is that all life is related and has descended from a common ancestor. It's considered to be an explanation of the origin of man. Many scientists believe that evolution is the force that connects all biological research and is considered a fact based on historical evidence. In fact, the debate by science is not on how it occurred. The debate on scientists is not on how it occurred, but whether or not it occurred. So some people will reject it for religious purposes. Now, teaching it has presented legal challenges. In the past, it has been banned because it's a direct conflict with the Bible's version of creation. Now, the U.S. Supreme Court, they prevented lawmakers from banning the teaching of evolution because it is considered a science rather than a secular religion. So the theory of evolution can be taught in schools, and well, that is up to the discretion of the school board. And the reason why you can teach it in school is because it is considered a science and not a secular religion. So again, whether or not the theory of evolution can be taught is to the discretion of each individual district school board. Now let's talk about religious garb. The wearing of religious garb by public school teachers raises the issue as to whether such dress creates an influence in the classroom. Wearing religious garb by teachers may be disallowed if their dress creates an atmosphere that impacts students. Many state statutes prohibit public teachers from wearing religious garb in the classroom. And the Pledge of Allegiance, which gets said every day in most schools. Well, students may not be compelled to recite the pledge based on their right to freedom of expression, because in the West Virginia versus Burnett case, the U.S. Supreme Court held that public school officials may not require students to salute and pledge allegiance to the flag. It's strictly voluntary. In fact, I've had a student before in my classroom that did not stand up for the Pledge of Allegiance. That was her and her parents' choice. So each morning we did the Pledge of Allegiance. She sat there and actually turned her back to the flag. That is her constitutional right.